Hey there, this is Drew Page, and in this video, I want to tell you how to not look like an idiot your first day of law school. Most of my subscribers know me by my Undercover Billionaire analysis, as well as some of my videos that I make based on my law practice. But what you may not know about me is I'm also a law professor. So I wanted to make this video for my students who may not know how to be prepared for their first day of law school, but also for anyone else who's interested in going to law school so that they can be prepared to know what it'll be like on day one so that they can shine like a star rather than look like an idiot. Now, why would it be important for you to be prepared for your first day of law school? Because law school is not like any other type of school that I know of. It uses what's called the Socratic Method. You say, what is the Socratic Method? Well, the movie The Paper Chase has a clip that pretty much sums it up. Let's see what the professor has to say about it.
We use the Socratic method here. I call on you, ask you a question, and you answer it. Why don't I just give you a lecture? Because through my questions, you learn to teach yourselves. Through this method of questioning, answering, we seek to develop in you the ability to analyze that vast complex of facts that constitute the relationships of members within a given society. Questioning and answering. At times, you may feel that you have found the correct answer. I assure you that this is a total delusion on your part. You will never find the correct, absolute, and final answer. In my classroom, there is always another question to follow your answer. Yes, you're on a treadmill. My little questions spin the tumblers of your mind. You're on an operating table. My little questions are the fingers probing your brain. We do brain surgery here. You teach yourselves the law, but I train your mind. You come in here with a skull full of mush, and you leave thinking like a lawyer.
Unlike many college classes where the first day is basically a summary of the syllabus and what you need to know about the class, and then the assignments come later after there's a lecture, law school from the first day is a firing squad. So you can be prepared to be called on because the professor will be calling on students throughout the class and asking them about cases. And you don't want to end up like this.
Now, I assume all of you have read pages 1 through 48 and are now well-versed in subject matter jurisdiction. Who can tell us about Gordon versus Steele? Let's call on someone from the heart, sir. Woods.
Oh, actually, I wasn't aware that we had an assignment.
Oh.
The interesting thing about that clip is that the professor doesn't have the students stand up to answer her questions. And there are few things as intimidating as having to stand up in front of the entire class with all of those smart people, because you don't get into law school unless you have some smarts, and stand up in front of that class full of people to say, I'm not prepared, or I don't know the answer. And it's a really embarrassing feeling, I would imagine. Fortunately, I did not have that experience because of what I'm going to tell you to do today. So there's two ways that you can really be prepared for your first day of class so you don't look like an idiot. Number one, I would suggest that you read through each of your assigned cases twice. The first time, you should read the case the first time just to get an overall understanding of what the case is about. So you can figure out the flow, you can kind of understand, the basics of the case. And so you give it one good quick read through so you can understand kind of what's going on. And then in the second read through of the case, I would do the second thing after reading, which is briefing the case. Now, briefing a case is not like doing a research paper. A brief is basically a summary of the case to help you so that you can jog your mind and your memory of what you read, so that if you get called on, you don't have to try to search frantically through the case to find the answer the professor is looking for. Instead, you have summarized it and understood it in your mind and written it out or typed it out on a piece of paper, so that you are ready and prepared to answer the professor's questions. Now, there's several things about a brief that you need to know. And in this next clip from the paper chase, I want to go through the interaction between the professor and the student to kind of help us see what we need to put in a legal brief so that we can be prepared for that first day of law school class. So let's check out this clip. But before we do, if you will, please take just 1 second to subscribe to my channel and like this video to help with the YouTube algorithm so that this information and content can get out to other potential law students and first-year law students who may need this. Also, you can get a copy of my book, The Right Defense for a Traffic Offense in Virginia, by clicking on the Amazon link below. All right, let's get to it.
Mr. Hart, I will myself give you the facts of the case. Hawkins versus McGee.
So first things first, make sure that you write the case citation name. The citation is the plaintiff versus the defendant if it's a lower court case. If it's an appellate case, like to the Supreme Court or to a court of appeals, the first name will be the appellant and the second name will be the appellee. Put the case citation name up at the top. Let's see what's next.
Is a case in contract law, the subject of our study. A boy burned his hand by touching an electric wire. A doctor who was anxious to experiment in skin grafting asked to operate on the hand, guaranteeing that he would restore it 100%. He took a piece of skin from the boy's chest and grafted it onto the unfortunate boy's hand. The operation failed to produce a healthy hand. Instead, it produced a hairy hand. A hand not only burned, but covered with dense, matted hair.
Here the professor is reciting the facts of the case, what happened to bring the case to court. So in your brief, after you have the case citation, the next step will be the facts of the case. What happened that brought these people to court? Now, there's generally two aspects of a facts of the case, and I kind of separate them. That's the facts that bring you to court, and then the facts of what happens through the court process. That's also called procedural history. And for some reason, students get those mixed up a lot. So think about it this way. What happened that got them into court goes in the facts. What happened once it got into court and throughout the process is the procedural history. So there's no procedural history that's given in this recitation by the professor, such that it would be like the trial court ruled that the child should be entitled to nothing because there was a healthy hand, it just was gross or whatever. Or the district court ruled that the child should get $200 million. And then the doctor appeals to the court of appeals, and the court reversed the lower court, and then they appealed to the Supreme Court. That's procedural history. So understand that distinction between the facts of the case, and you don't need to write every single fact. This just needs to be a summary to help you jog your memory about what happened. The facts section should be no more than 4 to 5 sentences max. Most of them should be 2 to 3, but never more than 4 or 5. Remember, it's a brief. It's not a book report. It's not something that should be a research paper. It is a brief. It should fit on 1 page. So no more than 4 or 5 sentences at the absolute max for the facts, and then 4 to 5 sentences max, but probably more 2 to 3 sentences for the procedural history. Now, a clue to help you find out what facts are important is the reason why I suggest that you read the case twice. The first time just to get a general picture, and then the second time to build your brief. Because the facts that the court relies on in its analysis later on are the facts that are going to be most important to the case. So make sure that you're keeping up with the analysis, because the analysis are going to be where those important facts are located. So that's kind of a quick tip to help you find out what facts are important. So let's see what's next.
Mr. Hart, what damages do you think the doctor should pay?
That part of your brief is called the issue. The issue is the question that the court is trying to answer. Now, the professor, in asking this question, is asking the question specific to these parties. But understand that a Supreme Court or a Court of Appeals does not take cases solely because of an issue between two parties. The reason they take cases is because they are trying to answer a legal question that hasn't been addressed or that needs clarification. So the issue should actually be written in a way that's bigger than just these two parties. So for example, the issue in this case would be, how does one determine expectation damages for a breach of contract? So that would be the issue that the court is addressing in this case. Now, you need to be prepared to answer the question of what the specific parties were seeking to have answered. So you need to know that. But understand, for purposes of a brief, your brief and the question for the issue that your professor is really trying to get at here is, what is the issue the court is trying to address? What question is the court trying to answer? Not just for these parties, but for all time. Because in theory, the later courts will rely on this rule under a principle called stare decisis, which means that they rely on past precedent. So this case would then be binding precedent on all lower court cases, and unless it's changed, it should be a principle that the court follows its own rules of stare decisis. So it's important to understand that the issue for your brief needs to be bigger than just the parties themselves. It needs to be more generalized and understood in a way that goes beyond just the litigants in this case, but answers the issue and the question that the court is trying to address.
What did the doctor promise?
There was a promise to fix the hand back to the way it was before it was burned.
And the result of the operation?
The hand was much worse than before he went to the doctor.
How should the court measure the damages? What should the doctor pay the boy?
The doctor should pay for what he did. And he should pay for the difference between what the boy had, a burned hand, and what the doctor gave him, a burned and hairy hand.
Well, he wasn't wrong. That is exactly what the correct answer is. But the movie, The Paper Chase, cuts off the rest of what happens, because he doesn't really get to what the rule was that the court used and how it applied it. So in fact, it cuts out, and he runs to the restroom and gets sick because he, I guess, was so anxious because he hadn't prepared the case like he should have. But what you should be doing next is looking at the rule. What rule did the court rely on in reaching its decision? So you want to look for statutes, code sections, or you want to look for citations within the case. Those are sometimes clues that show you what rules the court relied on in order to reach the result that it gives. Now, the rule is not the same as analysis. Analysis, which is the next section, or application, is how the court used the rule, applying it to the facts of the case. So the rule you state on its own, usually it's in one sentence, but there are times where there are multiple rules that the court relies on, so you'll want to list those rules as the court gave them. They generally will say, our decisions in the past have been this, or the General Assembly passed this law, or other courts have held this, and that kind of gives you a clue of what the rule is. Then in the next section, this should be your biggest section, and it's the most important section, is the analysis section, because analysis is the key to lawyering. Because understand, laws can change and courts can change their mind. Even though there is a principle of stare decisis, if you can convince the court that the previous decision was not the correct analysis and that a better analysis is for the court to rule in this other way, then you are able to make that argument to the court. And so understanding how to apply a rule to the facts is the most important thing you will learn in thinking like a lawyer. So that part of the brief of how the court takes those rules and then says, well, like in that case, or like with this rule, in this case we have this, and they start to wrestle with it, that's the analysis. So you'll want to put that there. And then the last part of the main case brief section is the conclusion. What did the court ultimately do? Did they reverse the decision? Did they affirm the decision? Whatever the conclusion of the case is, that should literally be just 5 or 6 words. The court affirmed the trial court, or the Supreme Court affirmed the decision of the Court of Appeals. That's the conclusion. And then in the last part, the very last part of the brief, I recommend what's called a notes section. So the notes section will be things like the concurring opinion or the dissenting opinion. With those types of opinions, you don't need to go through the same level of detail for the brief in your class. What you mainly want to get at is the main reason why the court is dissenting or concurring. If they're concurring, they're agreeing with the outcome of the court. They're just doing it for a different reason. So you need to understand what that reason is, and you can write that in a sentence or two. If they're dissenting, that means they disagree with the majority or plurality opinion, and you just want to know why it is that they disagree and be able to state that clearly. Another thing you may want to put in the notes section is what the court did not address, or things that were left hanging out there. So, for example, if we understand this idea of expectation damages, does that answer the question of how to actually calculate the damages? Well, no, it doesn't. So that's left for another case. Write down what this case didn't address, or what was left unaddressed or unsaid, and that will help you go a long way in being prepared so that you don't look like an idiot your first day of law school. Well, again, my name is Drew Page. Please subscribe to my channel and like this video to help with the algorithm. And you can get a copy of my book, The Right Defense for a Traffic Offense in Virginia, by clicking on the Amazon link below. Until next time, stay tuned.